Morning. Um, Agenda item number one today is the call to order. It's 10 a.m. on April 24th, 2025. I call this meeting the Citizens Clean Elections Commission to order. With that, we will take attendance. Commissioners, please identify yourselves for the record.
Christina Werther.
Galen Payton.
Amy Chan.
Yeah, Steve Tedla, good morning.
Good morning, Steve. And I'm Mark Kimball. We have all 5 members of the commission here this morning. Thank you. Item 2, discussion possible action on minutes for the March 27th, 2025 meeting. Commissioners, you have the minutes from our March meeting in the packet. Is there any discussion? Hearing none, do I have a motion to approve the minutes?
I motion to approve the meeting minutes for March 27, 2025.
Thank you, Commissioner Werther. Is there a second?
I'll second.
Thank you, Commissioner Payton. It's been moved and seconded to approve the minutes for the March meeting of the commission. I'll call the roll. Commissioner Titla,
Aye.
Commissioner Chan,
Aye.
Commissioner Werther,
Aye.
Commissioner Payton.
Aye.
Chair votes aye. The minutes are approved 5-0. Item 3, discussion possible action on the executive director's report. Tom?
Yes, thank you, commissioners. I think I wanted to highlight we'll be heading into the special election to have for a new congressperson in Congressional District 7 to fill out the remaining term of Representative Grijalva. We are working on the primary debate for that. I think we'll be down in Tucson doing some preliminary site work on that on the next week. And there are currently 3 Republicans and 5 Democrats who have qualified for the ballot. We are also going to do a digital voter education guide for that. That'll be available on our website. In the interim, there is a local election in several cities, and Alec has.
Excuse me. I have a question.
Please.
Commissioner Payton?
So is it going to be on TV or?
Yeah. So, I'll ask Gina if I'm missing any details, but we haven't got a firm date yet, but we will. The early voting for the CD starts on June 18th for the primary. And it'll be broadcast originate at the Arizona Public Media Studios in Tucson. And then the way we have arranged to do this is we use something called white labeling, which basically allows all of the broadcast partners around the state, radio stations, television stations, newspapers, to broadcast it just like our debate series in 2024.
Okay, so do you think PBS would pick it up?
Well, this will be at their
studio.
At their studio.
Okay.
So, and I'm not sure who we're using to moderate. I'm not sure, but we're using their studio to do it. I don't know if there's any, Gina, if there's anything you want to. Gina's the actual expert, obviously.
Gina,
and while we're waiting, I would just say thank you for arranging all that. I think it's really important, and I mean, and that district goes down to Douglas and Bisbee, and so I think it's real important. Thank you.
Gina?
Mr. Chairman, Commissioners, Commissioner Payton, yes. So as Tom mentioned, we will be at the AZPM studios in Tucson, where we will host the debate. It will be white labeled, so any media partner that covers CD7, but of course outside of that as well too, if anybody wants to pick that up, it will be open and available to them. We will have 2 debates in the primary, so one for the Republican candidates, one for the Democratic candidates, and then in the general election we'll have the final debate with those primary election winners. Yes, we are working with the Arizona Media Association again to this, so we'll make sure that all of our partners know that the debate is available and how to promote it, and we are going to, of course, promote it to the CD7 voters as well, so they know to tune in.
So the primary is July 15th?
Yes.
And then the general is when?
I believe it's September 23rd off the top of my head.
Oh, okay.
Right.
Okay. Thank you.
And someone was asking about moderators. Has that been decided?
Yes, so for the primary debates, we have confirmed that Steve Goldstein will definitely be one of the moderators. So Steve was a very strong presence for us in our 2024 debates. He moderated several of our broadcast debates as well as several of our legislative debates, and he handled the training for all of our moderators as well too. So Steve actually does work down there as well with that station, so he'll be very familiar with the process, and we're excited to have him back, but we are currently looking for a second moderator as well.
You should check out Jim Nensel. I like him.
Mr. Ninsel actually did work with us in the primary debates as well too, so we were excited to have him. Yes.
Known him
Thank
for
you.
years.
Okay. Thank you, Gina.
Thank
Thank you, Commissioner Payton. Tom?
Speaking of CD7, or a bit more, as you recall from our voter education plan, we are launching a Clean Elections podcast to supplement our voter education work. The title of the podcast is Beyond the Ballot AZ, and we will have our first episode available, we believe, the week of April 28th.
No,
Oh,
never,
good. Okay.
excuse me.
And that episode features a bit on CD7 and on we interviewed former Mayor of Tucson Tom Bolge about Representative Grijalva's history in the district and as a congressman and a former Board of Supervisors member. As you can see,
City Council.
well, Grijalva was on the.
Oh, I'm
Board of
sorry. I thought you were
Supervisors.
talking about
Yeah,
Bulging.
yeah,
Yes.
We've also continued to be out and about in the throughout the state. Avery's been to Pinal County recently, and then has been working on our voter outreach work group, which I can't say enough good things about. I'm very excited about us having a working group of the counties here, led by Avery. I think that's a really important step in solidifying our role there. I had the chance to go out to the LD28 Democratic meeting last week with, it was kind of an interesting bill. It was me, the county recorder, Justin Heap, and the executive director of the Arizona Democratic Legislative Campaign Committee, which is a pretty broad spectrum of folks to have talked to the Democratic Legislative Committee out there about running for office. I think those are the main things I wanted to highlight. I did want to mention that, we talked a bit about the executive order that the president issued related to elections, I think last month. The state has filed a lawsuit against that. And if you want, the link to the complaint's in the report. If you want to talk more about that at some point or have more questions about that. The upshot of the complaint is essentially that the executive branch doesn't have the authority to alter the time, place, and manner of elections under the U.S. Constitution. Rather, the Congress does. And so the president, by purporting to order the Election Assistance Commission to adopt different standards, is essentially taking on a policy-making role that belongs to the Congress under the Elections Clause of the Constitution. The last thing I do need to note is we received our notice. We do every 5 years we do a rule review report to the Governor's Regulatory Review Council. So that will be coming up here in the next few months, and we'll keep you updated as we get ready for that. We have an option to extend that for 120 days, essentially on request. I think at this point, I don't think we'll do that, but over the next couple of months, we'll be working on that report. And we will probably have some additional feedback for you about, how we want to proceed with those rules over which GERC has jurisdiction. So, I think that concludes my report. The legislature is still in session. and will be for a while.
Thank you. Are there any questions or comments from members of the commission? Thank you, Tom. Item 4, discussion possible action on MUR 25-02 and proposed repayment order for Anna Abatia, 2024 participating candidate for state legislature. This matter is the executive director's request that the commission issue an order that a candidate repay Clean Elections funds and make a reason to believe determination relating to a participating candidate's financial reports and records. We have the executive director present, and then Representative Abatia or her representative, I believe, is also present. So Craig Morgan is also here. He'll serve as our independent advisor for this matter. So if any members of the commission have any legal questions, please address them to Craig. Tom?
Thank you, commissioners. I wanted to start with sort of bringing us up to the minute. Yesterday, we got an email from Representative Abatia with some records related to her campaign and the financing or the expended, records that purport to be related to expenditures underlying some documents that purport to be evidence related to the expenditures. We haven't had an opportunity to review those thoroughly yet, but I think it's incumbent on me for purposes of this hearing with respect to the repayment order to say that, we're not going to ask you to go ahead with the repayment order now, pending our review of those documents. In other words, there are documents that, that at least purport to demonstrate that those expenditures were made for campaign purposes. We've looked at them enough to at least determine that's, what they purport to be. And so in view of that, given the way we framed the proposed order, we think that, and I think I have an obligation to say, okay, we really can't ask you to issue the order as drafted. And because obviously with the timing here, there would be no way for us to practically evaluate them and amend the order. We just are in a position where I think my obligation, and I also think, the discretion that you have would need to be exercised in that way with respect to the order. In other words, I believe that, I would bring it back if and when it needs to be. But we're not asking to move forward on that this morning. However, we do think that the reasonable leave determination on the issue of the late filings and the record keeping is appropriate to move forward on today. And just to put this in context from my perspective, where this sets us up, and for those who might be watching who may not have as much familiarity with our process here, a reasonable leave determination is not a finding. It's not an appealable action. What it is essentially a procedural step that ensures that I can, as a staff member, along with my colleagues, move forward with the steps that we deem appropriate to, ensure that there is ultimately compliance with the underlying allegations in the reasonable leave. So with respect to as to what sort of quantum of evidence there is there, it's more of a procedural question than it is is there X amount of evidence versus Y amount of evidence from our perspective. That said, if you look at the RTB, the two issues there are, one, the late filing issue. Clean candidates, just like any other candidates, obligated to file their campaign finance reports timely, and the Clean Elections Act has a penalty assessment that's allowed, which we're not at that stage yet, but a penalty assessment that's allowed for failure to file. That is different from, and in addition to, I mean, so it's separate from any other penalty that's available at law. So in other words, there is a provision of the what we call the regular campaign finance code, which says that Secretary of State or other filing officers are supposed to notice a candidate about their outstanding reports, and there's a process that they can follow to enforce that. The Clean Elections Act says, apart from that, the Clean Elections Commission has the authority to issue penalties that are different penalties against candidates, and there's also some nuance there about who is necessarily can be held liable for those penalties. But I think that we demonstrate in the report that from our perspective, there's no obvious evidence that the reports were filed, that the reports that were finally filed last on the 21st were not filed. They were filed untimely. That we've included the summary from the Secretary of State's office with respect to the amount of time there, and then we've also included the recent reports. So there's copies of those attached to the recommendation. The second issue is the record keeping issue, and I think there, notwithstanding that we now have this email with some records, I think that we know there that we had we have the late filing of the reports, right? So we had reports that were not on file for quite some time. We had outstanding audit requests for months that went unresponded to. We had a complaint out for the last month and a half that went unresponded to. And then in addition to that, we have, a communication from Representative Betia respecting the state of her accounts as of I think it was the 21st or whatever, maybe it was the 16th of last week. So, you take those together, and you might even be able to take them separately, but take them together, and there is at a minimum reason to believe that the record keeping obligations that are imposed by the Act and rules may not be met, which is sort of the standard, but we think it's very likely that they have not been met. Now, if it turns out as we work through this, and we do work through these things with an eye towards compliance, that there's some other explanation, or we can understand what's going on better, that's what we proceed from here. So again, we think there's reason to believe. We see this as a procedural vote on the part of the commission. We see the executive director and staff's authority to operate after reason to believe as independent from the commission in the sense that we will be operating. You're operating in a decision-making function, and we're operating in a investigatory function as we have in the past. And so, but that's really the sum total of my recommendation, just trying to boil it down. And then again, on the repayment order, I think that in view of the records we received last night, notwithstanding the fact that the time lag and what have you, the way we framed the repayment order, we really have an obligation, as I have an obligation as staff, to say, we would not ask you to move forward with that today, but we do think that the commission should vote to determine that there is reason to believe a violation may have occurred. So
I just want to make sure I understand this. So initially, we were dealing with there's the issue of the late filings.
Correct.
Or non-filings up till
Right.
very recently.
Right.
And then there's the issue of repaying the funds
Mhm.
that the candidate was given. So the second issue, repaying the funds, are suggesting we should set aside and not consider that right now. But you still feel that we should discuss and decide whether to proceed on fines for late or non-responsive filing.
As well as the record keeping issue. I think
Right.
we have enough, I think we have enough evidence in total based on the course of action, the admission in the email to Mike, to say that there is a sufficient evidence that there's reason to believe that there's a record keeping issue as well. So those two things, I think, yes, you're exactly right. As far as repayment, there may be, the rules as they're written sort of say, when we think there's a repayment issue that's arisen, we're supposed to come forward and raise that, right? And initiate that process, which we've done. The fact that we've now got some, records, it's not, this is not my preferred way to sort of be in this position where we have sort of have get the records dropped at the last minute and then we have to stop. But the evidence we had as of the time that I had to file the order in order to provide notice to the candidate, we had what we had, and that's changed. So we have to so it would be, it wouldn't do us any good to enter an order that I don't have that's framed around one set of circumstances when those circumstances have changed. Now, and we don't know if they will or not.
I have a
Okay,
question.
Yes, Commissioner Payton.
So the stuff that we have in our packet
Yeah.
dated the 21st,
Yeah.
there's been an addition since the 21st, as of yesterday, last night or something.
Yeah, well, right, Mr. Chairman, Commissioner Payton, what we received last night was a set of documents, invoices that are from well, at least the ones I think we've had a chance to look at purport to be invoices from the consultant to the candidate or to the campaign, both. That on their surface seem to at least say there was an activity here that was campaign, right? Yeah, beyond that, I'm not in a position to
Okay.
make a statement about whether or not their evidentiary value beyond the fact that beyond the fact that they purport to be that, I can't speak
Okay.
to.
But those documents need to be submitted to the auditors.
That they will be, yeah.
Okay.
That'll be part of our process.
Okay, thank you.
Are there any other questions from commissioners of Tom? Yes, Commissioner Werther?
Tom, so just to clarify sort of the process, so if we approve a reason to believe, so staff will then at that point obviously evaluate the documentation you received yesterday. Obviously, if it's recraft the repayment order, if that's actually what needs to be done, and then that would come back before us. Would there any other, anything else that would come before us in that type of situation?
Sure, right. No, Mr. Chairman, Mr. Werther, that's a good question. So in a kind of way, there are the procedural, there are almost two tracks. We kind of merged them here because of the way this sort of timed out. But I wouldn't say merge them when we move forward simultaneously. So repayment order. In the event that we review the materials and conclude that there's some discrepancy that we would need some refund, we would two things would happen. The first step we always attempt to do is to reach a settlement. Those settlements almost always come back to you for your approval. So that's, but absent that, yes, we would have exactly what you said, a recrafted repayment order that gets into what needs to, what there is there. The reason to believe, enforcement of penalties process is slightly different. We will have a investigatory process that will involve independent decision-making by the by the executive director. And then, typically one of two things happens. Again, there's a conciliation process we try to attempt to go through at various times. We have a mandatory one, further down the road, but we actually try to work that in, along the way. And then if the next step after that is typically, is briefing on what we call probable cause to believe. So the process there is investigation is complete. The executive director writes, essentially makes a motion to the commission to make a determination of probable cause to believe. The respondent gets the opportunity to write writes a response brief. The executive director has the opportunity to review that brief and decide not to go forward. And then if we go forward with that, then there is a sort of an adversarial hearing, which would be to make an actual finding. There's an additional sort of parallel process that occurs at the same time for determining the penalty. So typically what we will do is if we get to a point where there's probable cause to believe, we make a motion on that, and then we make a separate filing on that we'll do at the same hearing on assessment of penalties. And then that becomes the order of the commission. The respondent under the current rules then appeals to OAH. OAH kicks it back to the commission. The commission, depending upon how that goes, a respondent can go to Superior Court, and then 10 years later we can find out what happened. We try to avoid that last part because of the costs and because if we can get an accounting of the what happened, the statute 6957 talks about it really talks about a public administrative determination, right? It's sort of like it's designed to sort of say to the public, okay, here's what happened, and that's sort of at least in principle what we try to do. So those are the steps that we undertake as staff, independent of the commission. So we'll only touch base with you along the lines, as we go along. To really flesh out this, I mean, you've seen in other cases, if I subpoena a person, that person has a right to go to the commission to have that subpoena quashed. That's another sort of thing that can happen. But I think that the main points are, this is a procedural step that's built into the rules. And then the more substantive stuff will come, you'll make, maybe if we were in a position to, we'd be asking you to make substantive determinations at another time. That may be too much
No.
answer, but
No, that was helpful. Yeah, I just kind of wanted to know the tracks and then what our role is and then that process. Thank you.
Well, let me clarify something to follow up on what Commissioner Werther was asking. So today, you are not asking us to make any kind of a motion.
no, that's not that, Mr. Chairman. I would say what I would ask, and if you look at the last, I think it's the second to last page of the recommendation, maybe the third to last page. If three of you were to vote to determine that there's reason to believe that authorizes the executive director to undertake an investigation, there's an outline of steps that I may take after that. And then, the other thing that could issue, that the executive director can issue at that point, is an order of compliance. That order of compliance can happen anytime after 14 days. So that's so we definitely need we are asking for an affirmative vote of 3 members to determine that there is reason to believe as outlined in the memo. So in other words, you don't have to, the memo distinguishes between the reason to believe aspect and the repayment order. So I think, we would think that a motion along the lines of, that there is reason to believe that, that the commission determines there is reason to believe for the reasons outlined in the statement of reasons of the executive director would be sufficient for our purposes. And that's what we're asking for, staff. Obviously, you may have other
Right.
questions about that related
Okay.
to your own, what procedural steps you might think other people, I want to say this is what I'm telling you, I think.
Right.
It may not be what your lawyer thinks.
Okay, thank you. Any other questions or comments from the commission? I believe we have a Representative Abatia with us today. Representative, is there anything at this point you would like to say to the commission? We're somewhat at a disadvantage because we haven't seen the most recent material, which you apparently provided sometime late yesterday. And I have a number of questions based on the material we had 24 hours ago. But I want to give you an opportunity if there's anything you wanted to say.
Hello, yes, can you guys all hear me?
Yes.
Okay, I'm in my car, so yeah, so I just wanted to take accountability for not getting my reports in and getting the information over to you all. I'm not making excuses. I just was lacking in responding to my emails while switching over to new emails with the ledge and just getting transitioned over as an elected. Yesterday, why I didn't send the report so early or sent it so last minute was I was told to wait until my reports were submitted and amended by my new finance person who went in and made sure everything was done correctly. So that way the invoices and everything kind of matched. They didn't want it to look weird. And then yesterday we were kind of back and forth between recess and meetings, negotiating for DDD funding. So trying to get this reported to you guys, not on my state laptop and trying to do it on my personal laptop. There was just a lot happening at that moment. So I do apologize for bringing this in so last minute and not, doing my part on getting these reportings done. I just want to take accountability for that. I do have all of the invoices that I sent over from the beginning of the primary all the way to the end of the general. I think more than what the audit would be asking for, just so you guys all can see what all of the finances were spent on. And then I am willing to work 100% with you all moving forward to get whatever reports need to be submitted.
Thank you for that. Let me ask you a couple questions, and maybe these have been answered in the material you've turned in recently, but this isn't really last minute because the questions I have go back to last July. In your operating expenses filing. In mid-July, you had a $20,000 payment to Gumption Consulting listed only for professional services. Then 11 days later, another $3,500 with no details, just professional services. Then 3 days after that, another $3,500 for professional services. So in basically, and then 2 days after that, $910 professional services to Gumption Consulting. So in a 2-week period, it was almost $28,000 just listed as professional services. And then in August, $20,000 also to Gumption, but this time listing for administration payroll. So this was over a month and a half, about $48,000 that there's no explanation, just consulting services and then the same amount as previous payments, but this time for payroll and administration. And that just seems woefully inadequate explaining what this money was used for. And I couldn't help noticing that It was made to a consulting company that has the same address as you do. So I'm very puzzled as exactly what is going on here with large sums of money with no billing, no explanation, going to someone at your address. And is there anything here that you can shed light on?
Yeah, so um, I am not a finance person, so I apologize for not putting in detail of what all of those expenses were for. Um, as far as for paying Gumption and my relation, that is my fiance's business. But how it works for not just myself, but he has worked for other clean elections candidates and multiple traditional candidates throughout the campaign. He just paid the company, and he has his own vendors that he uses for services like literature, getting literature printed, getting mailers done, things like that. So if you were to go back and look at other electeds that he ran, specifically election candidates, you're going to see the same type of reporting. The I believe it was, you said the 20,000 for the for the payroll, correct? That is for canvassers. That was to pay canvassers. Canvassers are not paid through my campaign. They are employees of his company. I just pay him, and he pays his canvassers to go out and knock on doors. So a lot of the money that was being paid to Gumption was to pay for, and you'll see that in those invoices, was to pay for canvassers, to pay for literature, to pay for graphic design, to pay for mailers, and things in that nature. I was working in my primary campaign. I was slated with another clean elections candidate, so you'll see like there's half of the payment for those, because legally we have to split those payments up, right? We have to split the cost. So you'll see that along with some of the mailers, I believe. So a lot of this was to get all of those payments covered, essentially, throughout the campaign, all of those campaign materials.
Well, let me just address a couple of things you said. First of all, you said you're not a finance person, but I believe you went through some training offered by Clean Elections about how to fill out these forms as a condition of receiving money from Clean Elections. Is that correct?
Yes, but I mean, campaign finance is very complicated to understand, even going through a training.
Okay. And our staff, the Clean Elections staff, has made numerous attempts to reach you over the past 9 months. And now you have someone doing this. Why did it take so long for you to respond and to provide the material that Clean Election staff has been asking for many months?
Yeah, so like I said, I switched over to my Ledge email, and I've been really communicating most of everything through there. The email that I was being received with emails from Clean Elections, I had been locked out of that email for not using it for a while. So even when I was trying to get in to get all of my the information to give to this finance person that I hired, it took me a couple hours to get into this email. So, but again, that I'm not making excuses. I'm just letting you know where I was at.
Okay. Do other members of the commission have any questions for the representative? Okay. Tom Craig, is there anything you wanted to say? Could you come up to the microphone, please? And if you could just identify yourself for the record.
Hi, Craig Morgan, Taft, Stettinius, and Hollister. Here as an independent advisor to the commission. Mr. Chairman, I don't have anything to add. But if you have any specific questions for me or concerns, I'm happy to discuss them with you in executive session, answer any questions you may have, give you any legal advice you need.
Okay. Any questions in open session for Craig, or does anyone feel a need to go into executive session?
I would like to go into executive session.
Okay. I guess we need to vote on this. Okay, is there a second?
A second.
Okay, there's been a motion, a second to go into executive session. I'll call the roll. Commissioner Payton,
Aye.
Commissioner Werther,
Aye.
Commissioner Chan,
Aye.
Commissioner Titla.
Aye.
Chair votes no, but it's 4-1. We'll go into executive session. We are back in regular session. Just for the record, I want to make clear that the executive director was not part of our executive session. We met solely with our legal counsel. So after our discussion in executive session, does any one member of the commission wish to make a motion?
Mr. Chairman?
Commissioner Werther?
I move that we proceed with the reason to believe violation for the reasons outlined in the statement of reason by the executive director as discussed in today's meeting, including the candidate statements acknowledging failure to comply.
Thank you, Commissioner Werther. Is there a second?
I'll second.
Thank you, Commissioner Patton. It's been moved and seconded that we proceed with a reason to believe. I will call the roll. Commissioner Werther,
Aye.
Commissioner Patton,
Aye.
Commissioner Titla,
Aye.
Commissioner Chan.
Aye.
Chair votes aye. The motion is approved 5-0. And thank you, Ms. Abieta, for returning to our meeting. I just want to make clear that all of us feel this is a very serious matter. And it's very concerning to us that it's gone on this long with this amount of money, which is public funds, in question. I appreciate you turning in some additional documents. We expect that as the commission staff goes through these, that you will offer your total cooperation to them and to our auditors so that we can bring this thing to a close. It is serious. It is not a minor issue. It is our expectation that our next meeting in May, that we receive an update on this and that we try to move towards a resolution in a quick manner. This isn't going to drag out forever. So we're going to need your cooperation in explaining these late documents that you just provided substantially after the deadline. And please understand, this is very serious. It's not a minor oversight, a minor financial misunderstanding. It's a very serious situation, and I hope you understand that.
Yes, thank you. And again, I appreciate you all for letting me be here. Again, I just want to admit my lack of failure to report everything. Again, I'm not making excuses. So, and I do understand the severity of it and the importance of this. So, moving forward, I will be working with you all 100%. So, thank you.
Thank you. And our next meeting is scheduled for May 22nd. And I hope that we'll be moving towards some kind of resolution of this by then. Thank you. Any other comments from members of the commission before we move on? Okay. Item 5, discussion possible action on Americans, for Prosperity v. Meyer, number 24-2933, 9th Circuit, oral argument, May 15th, 2025, 9:30 a.m., ceremonial courtroom, Sandra Day O'Connor, U.S. Courthouse. Commissioners, next month, the 9th Circuit Court of Appeals will hold oral arguments in the case Americans for Prosperity versus Meyer. Our attorneys in that matter are available to brief us on that matter. Is there a motion to go into executive session?
I move to go into executive session.
Is there a second?
I'll second.
It's been moved and seconded that we go into executive session to discuss Prosperity versus Meyer. I'll call the roll. Commissioner Werther,
Aye.
Commissioner Patton,
Aye.
Commissioner Titla,
Aye.
Commissioner Chan.
Aye.
Chair votes aye. We will be going into executive session on this matter. Okay, we are back in regular session with item 6, public comment. This is the time for consideration of comments and suggestions from the public. Action taken as a result of public comment will be limited to directing staff to study the matter or rescheduling the matter for further consideration and decision at a later date or responding to criticism. Please limit your comment to no more than 2 minutes. Does any member of the public wish to make comments at this time? Seeing no one there. I don't believe there are. The public may also send comments to the commission by email at ccec@azcleanelections.gov. Item 7, at this time, I would entertain a motion to adjourn.
I move to adjourn.
Is there a second?
Second.
It's been moved and seconded that will adjourn. I will call the roll. Commissioner Chan,
Aye.
Commissioner Titla,
Aye.
Commissioner Payton,
Aye.
Commissioner Werther,
Aye.